Now he is in a cross. He is in a really tricky pickle, because we have this murder trial, and then he has these theft trials, this theft trial that's outstanding, that he has not pled to, that he's a presumed not guilty, and that is upcoming. So right now, think about how the state has played this. If he takes the stand and testifies, and they can ask him about the financial crimes, then he will have to admit guilt or be deceptive to the jury. See? So they'll get a confession out of him, a forced confession out of him, by leveraging a garbage murder trial to get him to plea and admit guilt on a collateral crime. Make sense? Hold on a second. Dog. So he is in a catch-22, or he is forced to make a Hobson's choice, which is the thing I had to look up. He is made to make. So the state is taking this weak garbage murder trial and using that to extract a confession out of him on the witness stand. All right. So therefore, now the next problem is, and the reason is because all this financial stuff was brought into this trial. If it had been kept out, he would never have had to face that. So error number one begets error number two, which is now he's facing this choice of, do I testify or not testify? If I testify, will I be asked about the financial, or can I plead the fifth and can I not do it? Okay, so let's talk about that. Different possibilities. The first is the way it should be done. And what the judge, my first Rumble rant ever. Steve, you're great. Oh, so are you, Red Taker. The first thing is the judge should explain what the thing. He should limit the state. And here's the way you should say it. Well, at this point, I'm ruling that his testimony is directed to the murderer, that any questions he can either plead the Fifth Amendment and not be forced to answer, or he can take the stand and which is probably what I think is going to happen, by the way. I think he's going to take the stand and plead the fifth on those. All right. But there's a couple possibilities on that too. Or he could say, you can take the stand, but if the defense opens the door, I want the state to, outside the presence of the jury, make an argument that the door was open before you get into the financial crimes. He should do that. I think that's fair, because then he is fully advised as to his potential benefits and risks for taking the stand. I think that's fair. It's a fair trial, isn't it? Don't we want to be fair instead of catching him in this catch-22, which is what he's in now because of the previous error the judge made by letting all the financial stuff. Okay, so now let's assume that the judge isn't going to do that, which I don't think they're going to do. I think the judge is going to be reluctant. He doesn't want a pre-rule, which is in essence allowing the state to get it into cross him. All right. They're forcing him to make this decision. And the defense attorney now has to advise their client based on the fact that they think the door will be open, he will be asked. And then he will have to invoke the fifth. All right. So that's the first thing. Or second or fourth or 20th or whatever, or number one. The next thing is, before Murdaugh testifies, the judge is going to have to give him a full plea colloquy. And he's going to have to say, this is your choice. You've been advised. You need more time. If you remember, the defense said, we want you to go ahead and advise him at the end of the day. I was expecting that today, but I think they're going to go back and do some more research before they do it. But by the judge giving the colloquy, they are going to force that judge to make that call, or advise him or not advise him, and give him he's basically compounding the error at that time. The defense is also creating what they call harmfulness, because they're going to make this record very clear that he is placed in a position of jeopardy that he cannot resolve because of this financial crime, and it makes it added damage to him. It gives him an unfair trial. All right, so now let's assume he takes the stand, and then the state gets to ask these questions. The state asks the questions of him, and he pleads the Fifth Amendment. What the state will then say is, no, he took the stand. He waived his Fifth Amendment privilege by testifying in this case. All right, that's what the state's going to say. The judge may sustain. He may say, that's true, you waived. I'm ordering you to answer the question. All right. Now, there's two things about that. One, I don't think that would be proper. Two, I think the judge will do that. And I think he would do that. Three, what if Alex Murdaugh just says, to hell with you? I've answered what I wanted. I said what I can. If he wants to stop questioning, he can, but I'm invoking my fifth all day and all night. And then the more you force me to, the more you're showing what a kangaroo court you got. So I would if I was Alex, I'd stick to my guns and say, well, I'm sticking to my fifth. All right. And then what's the judge going to do? Hold him in contempt? Okay, what's he going to do? I mean, he's facing life in prison. Hold me in contempt all day, judge. Do your worst, right? So that would be my responsibility as Alex, but I'm a disagreeable guy. And let the jury see what a railroad it is. All right, so the next thing is, let's assume that the judge orders him to testify, orders him to answer the questions, and he does. All right. The next question is, can the state use that in the financial crimes trial to be good? So let's assume he testifies, he's forced to answer, he does answer, but then he gets a not guilty on the murder. Yay, not guilty. But then he's facing the financial crimes. He's got a full confession in this trial under oath. At that point, now the question is, can the state bring that in as evidence against him in the financial crimes trial? Well, one, if he's ordered to answer, if he's ordered to talk, there's basically, he is being forced to give up his self-incrimination right. To me, there's a possibility, and this is very, if it's the same judge, he's going to screw him again. But if it's not, I think there could be what it's called. It could be excluded because, and it's called that Hobson's choice. Because you can't. Here's the idea: you can't give up the one right in order to exercise another right. And I tried to do the research on this. If I had this on appeal, I would put a lot more time and I would dig this out. But there is this idea that in order to, like, for example, if I have I want to enforce my right to, I don't know, I can't think of it now, but I want to enforce a speedy trial right, say. I don't then waive my right to speak. Okay, so for example, I'm or right of self-incrimination. So I want to ask for speedy trial. The judge then says to me, is this your decision? Are you comfortable with your attorneys? Are you want to waive for your trial? When he speaks, now can the state says, he spoke and he waived? No, because he's explicitly enacting his right to the speedy trial. That's a bad example, but it's as close as I can come right off the top of my head. You can't lose one right by enforcing another. And so that's what he's doing here, where he's basically he has the right to testify on his own behalf in a trial to defend himself. He has that right. He also has the right to remain silent. So by asking to testify, he is giving up the right to remain silent in the other independent case, you see? So he's facing this Hobson's choice. So that is a very good appellate issue. So that's what we have. Okay, so let's see where we are on the Super Chat. Thank you for your insight. We're also happy you're part of the Law Group. Oh, Law Group. Okay, we can do that. Not Law Tube. I don't know what Law Tube is. Okay, so I think we're caught up on the Rumble rants. So, if we're caught up in Rumble rants, then I usually watch the chat. I love the chat. So, but I haven't been paying attention to the chat because I'm solo. If I have I think I'm a better wingman. And maybe, so are we done with Murdaugh today? Do we have anything else? I'm looking at my chats here. There was also some testimony. Well, we addressed most of this. I think he's an asset. I would put him on the stand. I really would. First of all, it would compound the error, the appellate error. And as a good appellate attorney, I like that. Make the error even more damaging. And I'd just I'd put it on the stand. Well, you judge, you're not giving me a choice here. I'm facing murder and I didn't do. So I'd make that record real clear.